Victims of online harms will soon get better support under new laws. A new dedicated one-stop government agency will be set up, which, for one, will help to speed up processes like the taking down of harmful material. Offenders will also be held accountable. This comes as a recent government survey showed that more than 4 in 5 people encountered harmful online content in the past year. The new Online Safety Commission may issue directions and restrict abusive accounts when needed. The agency is expected to start operating by the first half of next year. It'll address 5 types of online harm first, including online harassment, doxing, and intimate image abuse. 8 more will be progressively added, such as online impersonation, incitement of violence, or enmity. Victims can seek legal recourse under new legal rights known as statutory torts.
Victims may seek damages that the court finds just and equitable, and other hits of damages that the minister may prescribe in regulations, such as compensation for loss of earnings or an account of profits where perpetrators benefited from the harm. The intent is to ensure that victims are properly compensated and that wrongdoers are not allowed to benefit from their behaviour.
The Workers' Party MPs had proposed several amendments before the bill was passed, mainly over how some parts are worded. Non-constituency MP Andre Lau voiced concerns about legitimate speech, saying that even fair criticism could be seen as abusive and classified as harassment. He suggested adding clearer wording to make sure the law protects people from online harm without silencing free speech.
Our amendments do not weaken the bill, they sharpen it. They ensure that the Commissioner's powers are used to protect victims, but not to chill legitimate speech. They prevent this bill from inadvertently silencing criticism, investigative journalism, or public interest disclosures.
The OSC can consider whether the comment was reasonable and the circumstances the comment was made in deciding whether OSC should issue a direction. This allows the OSC to weigh whether something counts as fair comment or public interest while also considering the features of the post and not immediately say it cannot act. So if a member of a public raises in good faith or exposes serious wrongdoing, this will be taken into account as part of OSC's case assessment.
The Workers' Party also suggested that the Online Safety Commission, or OSC, should only act when there are reasonable grounds to believe that harmful acts have taken place, not just on suspicion. The law allows the Commissioner to act on when they suspect harmful activity. In response, MP Tin Pei Ling says raising this threshold could slow down action and leave victims exposed to harms for longer, while authorities gather proof.
Members' proposed amendments seem to suggest the removal of finality to appeals and to switch from reason to suspect to reason to believe. These will drag out the process and extend a victim's exposure to harm. I do not think that these are helpful to victims of online harm.
I believe the member said that this might actually prolong the process and cause further harms to victims. And I just wanted to clarify how she thought that this would be the case.
From reason to suspect, it means that when the harm is first detected, that allows the agency or the authority to quickly step in and take measures to remove the harm. That's one. But to change it to reason to believe will mean that there must be sufficient grounds established to prove that there is indeed harm. And this process will take time. So during this period of time, I am fearful or I am worried that this will cause the victim who is already traumatized to be exposed to the harm further.
Several MPs also raised concerns around practical realities that the Commission will face. This includes the potentially high number of caseloads and access to resources.
Who will be the caseworkers and how will the OSC caseworkers assess the incidents? Will they be doing it manually and how do we scale it up quickly? I guess the key point I'm trying to make is how do we adequately resource the OSC with the expertise, the manpower, the technology required to ensure that victims can get effective and timely relief. We need to set the OSC up for success.
I'm cognizant that speed also requires resourcing. the Commissioner Office should be staffed and supported to act with urgencies. I would welcome the Ministry plans for resourcing so that operational targets are achievable rather than aspirational.
We estimate the initial caseload of the OSC to be high, based on various factors, including Australia's e-safety caseload for similar harms, adjusted for Singapore's population. Depending on the volume of the case, we will calibrate and reallocate resources as necessary to resource and size the OSC adequately.
In his wrap-up speech, Law Minister Edwin Tong thanked members for their support of the law and their thoughtful contributions to what he describes as a very important debate.
I'm very heartened to see that actually we are on very common ground, not just in our thoughts and in the way in which we want to advance the bill and the work of the OSC, but also in our views and in our values on what this means to society. And I think ultimately, after almost 8 hours, I think we are not really disagreeing on much. And I found speeches on both sides of the House thoughtful, with good suggestions, and even if we are not able to take them on board today, I think they will be relevant for future iteration of this bill.